everyone. Welcome to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about what to expect from a litigated divorce. What does it look like? How do you prepare? And what exactly does it entail? To discuss this today, I've invited Jackie Marks. She's a family law barrister with 30 years experience, and she sits as a deputy district judge in the family court with a ticket to hear both private children and financial remedy cases. Jackie is also an accredited resolution mediator and one of the founding partners of the Mediation Space, which is a multi-disciplinary mediation service in which all the professionals are trained in psychoanalytic psychotherapy. Thank you so much for joining us, Jackie.
It's my absolute pleasure. Thanks for asking me, Chloe.
I'm really pleased to have you today because who is better placed than a judge to give us that view from the bench of what litigation looks like? It's kind of that hidden realm of family law, or of all law actually, where people don't get to see into the courtroom. And a lot of my clients are actually quite worried and uncomfortable with the process because it's unknown, because it's so formal and official. So it'll be really helpful to understand from you exactly what it looks like to hopefully demystify it a little bit.
Yeah, that's completely understandable, Chloe. I mean, people are usually, when they're coming to court, in a very difficult situation in their lives, and it can feel very stressful and alien to go to a court without really knowing what to expect.
Absolutely. Absolutely. So hopefully this will give them all the information they need. Of course, their solicitors are there to advise. I help a lot with preparation before court as well. But all of this brings it to life from someone who's in the courtroom day in and day out. So should we start maybe with a broader picture, which is trying to explain in broad terms and in your opinion, what the value is of a divorce that is negotiated versus a divorce in court? What are the pros and cons of each option?
Well, it's a really good question to start with, and I think there are numerous reasons for preferring a negotiated settlement over going to court. First of all, if you go to court, there is likely to be a significant delay before you are in a position to resolve the issues that you wish to resolve. Just by way of illustrating this, a little bit of data. In 2015, children proceedings took, on average, 26 weeks to resolve from the beginning to the end. That's half a year. Yeah. In 2021, that timing had increased to 40.5 weeks on average. Yeah. And 25% of those applications were returning cases. In other words, they'd been through the process of going to court before. So that's a very significant amount of time. And actually, in my own experience and opinion, I've seen cases, particularly regarding children proceedings, that can take more than a year to resolve. Okay. And that delay leaves everybody in limbo. It leaves them stressed, it leaves them anxious, and not least the child or children who sometimes are not able to see the non-resident parent until those issues are resolved. Yeah. And research has shown that conflict between parents is harmful to children, both emotionally and in respect to their brain development. Yeah. So coming to court only increases bad feelings with the consequential upset for the child or children. Now, a negotiated settlement through either mediation or early neutral evaluation, or even through arbitration, is both quicker, cheaper, and much less attritional as a way of settling a dispute about finances or children. It allows the parties to reach a bespoke solution that's likely to be more sustainable, and especially so in Children Act proceedings, than an order imposed on them by a judge who doesn't know the children, and it can only make an order within the particular framework that the law allows. And that framework very often does not make allowances for the emotions that underpin the difficulties that led the parties to being in conflict in the first place. So the sort of mediation that I do, for example, which is a way of resolving matters out of court, is one in which I work alongside a psychotherapist, which enables a facilitated discussion and for the parties to be able to express, if they want to, their anger, their upset, their anxiety about the future in a managed environment. and in my experience leads to very successful and moreover enduring negotiated outcomes, ones that stick and don't result in matters going repeatedly back to court because the parties are just having to live with a solution that's been imposed upon them other than one that they've arrived at themselves, looking at what their common objectives are.
Completely agree. And it's true that retaining that control over something that's going to impact you and your children, your life, it's really important. Of course, you're just delegating the decision making, and sometimes there's no choice. But if there is that option, it's always better to make your own bed.
Absolutely. Anything is better if you can find a solution than actually asking a court to impose an outcome upon you.
Yeah. And then I guess there's the value also in terms of the relationship, especially when there's children. The parents are going to still co-parent afterwards. Knowing how to resolve those issues out of court is also quite important. You're not going to be able to go to court every time there's a disagreement. So it's also a skill that's acquired during mediation that they can use later on.
Yes, and I think in mediation, we concentrate quite a lot on communication because that's really the starting point. And very often it is about communication, and parties come to mediation sometimes when they haven't spoken to each other for 6 months, 12 months. And we start off with, actually asking them how they feel about being in mediation, talking to each other. And that can be quite revealing. And they settle into it, and they find for the first time that they're able to have a proper managed discussion in which they can make that they're surprised sometimes that they are actually on the same page about issues that they haven't been able to discuss together. By having a managed discussion in which they feel contained.
You mentioned in the context of a litigated divorce, the time constraints. And of course, the courts are under more and more pressure. But aside for the number of months it takes, in terms of the number of hearings that it would typically take, how does that usually unfold?
Yes, well, there are a number of hearings. So if you go to court to resolve your child arrangements, commonly you would each parent would be contacted by a CAFCAS officer. That's a child appointed worker appointed by the court who will undertake an assessment to consider whether there are any safeguarding issues. If there are safeguarding issues, there may have to be what's called a fact-finding hearing, and that involves the court hearing evidence and deciding between the truth of two conflicting accounts to determine the issue of risk to the child or children, and that informs the welfare decision about how the child's time should be spent between the parents going forward. If there are no safeguarding issues, the normal process is that there is a first hearing dispute appointment at which both parties attend, and many cases do actually resolve at that first hearing. It is possible, that with the help of a judge who is very proactive, that cases can resolve. But if they can't resolve, then there is a second stage, which is the dispute resolution appointment. That usually takes place about 20 weeks later after a CAFCAS report has been obtained, in which the wishes and feelings of the children have been ascertained, or any other expert evidence that's necessary. And then there is a final hearing. And you can see how long that process might take, particularly if there has to be a fact-finding hearing before you can even go on and decide on welfare issues. In terms of financial matters, there is the first dispute appointment, which is an administrative appointment to gather information, and then what's called a financial dispute resolution appointment, where the parties both attend court with a view to reaching a negotiated settlement with the help of the judge, who'll give a confidential indication as to the likely outcome. And then if the case doesn't settle at that point, and some cases do settle, in fact, I'd say the majority of cases do settle at that point, but there are many that don't, then you can expect a final hearing. And again, I would say, the time delay for a final hearing can be as much as 6, 8, or even 12 months.
If people can't agree on the financials or the children, they have to follow both tracks of hearings.
Absolutely,
the whole law.
And the cost of that, both from the pounds and pence point of view and emotionally, is enormous.
Yes, I think people often underestimate the stress of going to court as well. Exactly. They think it's going to be their moment of emotional justice, and it really isn't. And it can be very difficult to hear the other person, their representation saying negative things, and it's very damaging.
You're absolutely right. And, doing the best that you can as a judge, you've got maybe 5, 6 cases in your list that day, and you simply don't have time to hear the background, to hear everything that the clients feel that fairness and justice requires the court to hear, because you know as a judge that isn't actually necessarily going to impact on the decision that you make. And people can feel shut down and not heard, and they can feel that the process is unfair. And the judge can only do what they can do within the time that that case has been allotted. So it's really, sometimes court can't be avoided, but if there is another way, then, I would urge parties to try looking at an out-of-court resolution.
Yeah. And not to put you on the spot, but off the top of your head, what percentage of cases would you say go to a final hearing?
Well, there must be some data on this, and I don't have the data off the top of my head. I would say that a lot of cases do settle at the dispute resolution appointment hearing or at the financial dispute resolution hearing.
Okay.
But what I would say is that cases that settle at the DRA do so usually because a judge is giving a strong indication as to the likely outcome. And sometimes one party feels that they've given in, and that's where things become unsustainable. And that's why if you go to mediation, you are making the decision yourself. You are signing up to an agreement that you have reached rather than one that you have it had imposed upon you, either because you've consented to it because you've heard some harsh words from the judge, or because you feel that you've got no choice but to accept what's on offer.
I think that's key. And then in practice, I guess, in terms of how the hearings happen, are they online? Are they in person? Is it a mix? How does it usually work?
Well, as far as proceedings concerning children are concerned, these are all attended in person, unless there is an exceptional reason, which might mean one person is abroad, or occasionally, if it's really a truly administrative hearing, just what we call directions, then the judge might direct that the parties need not attend. It can be a remote hearing, but generally speaking, parties should be attending court for children proceedings. For financial proceedings, it's slightly different. The first dispute directions appointment is often held remotely, with the parties attending by Teams or some other video platform. Although many courts also require parties even to attend for the first appointment, but certainly the financial dispute resolution appointment and the final hearing are usually attended hearings, so that the court can give the parties a chance to give evidence if they need to, actually in the courtroom. Yes, so that's my answer.
And in terms of representation, I know I saw some stats recently that showed that more and more people are self-representing because of the cost of divorce. Do both online and in-person hearings have usually a barrister attached to them, or is there a difference in approach?
No, there's no difference actually. I mean, the truth is that representation, the ability to be represented, depends on the party's finances, and it can be very costly to go to court. There's almost no legal aid for financial matters, and for children disputes, it's only available if the person claiming legal aid is the victim of domestic abuse. And so it's very difficult. Many cases come before the court with litigants in person who are obviously disadvantaged, because not only are they having to deal with representing themselves in their own very stressful case, they're dealing with a very environment that's really completely unknown to them.
You noticed as well an increase in people who are not represented?
Oh, over the last 10, 15 years, enormously so. Absolutely.
And so for people who aren't represented and don't have that support in preparing logistically and emotionally for court, what would be your tips, I guess, in terms of getting ready and showing up at court as a credible party?
Well, to be a credible party, I think, you need to be fair, and you need to be prepared to make some concessions if you need to. So don't over-egg your case on the basis that you think that, you've got to get every point across. And also don't be defensive. It is, at the end of the day, an inquisitorial process rather than an adversarial process. It can seem very adversarial, but I mean, the court wants to do what is fair and right for both parties. But there is a tendency sometimes to become very defensive. And I would urge, if it's avoidable, not to be defensive, just to try and be respectful and, as I say, make some concessions. Because at the end of the day, if you aren't prepared to make concessions, you are heading to a final hearing.
Yeah. And then with the changes in the family procedure rules, I guess there's also an element now with people's openness to negotiating and that being taken into account.
Yes, yes. Well, absolutely. There is a real emphasis on making realistic offers, particularly in financial proceedings at an early stage, with an effort to try and resolve matters and to save costs. And absolutely, that's really very important.
So are there any common errors that you see people making that you would caution them to be aware of?
Well, I think I've touched on one of them, and that is not being focused on the issues that the judge needs to hear. Or needs to resolve matters. So wanting to tell the judge all about the history, sometimes people feel it's the first time that they've had an opportunity to tell their side of the story, so to speak. And as I said, it's an imperfect process, and the judge simply won't have time to hear everything that you want to say on your behalf. So try and be focused on the issues that the judge is going to have to decide.
Yeah.
The other error is not complying with the court's timetable, with directions. It's very important if the court makes directions for the filing of evidence or obtaining evidence, information. It's not an option. People need to comply, because that's only going to get you into difficulty with the judge, and cases often have to be adjourned if people haven't complied with directions, and that prolongs matters, increases costs, and just delays the proceedings.
Yeah, so that makes a lot of sense, actually. I think that's the point of the direction, just to keep things moving, and if nobody does anything about them, the judge must feel quite frustrated. And in terms of the duration of a hearing, how long can people expect it to take?
Well, I think I've sort of alluded to this at the beginning of our conversation. With Children Act proceedings, you could be looking at 12 months plus until a judge, if there is a final hearing, hears the evidence and makes a decision about the arrangements for your child. With a financial remedy case, I'd say between 9 and 12 months from, again, if there's a final hearing. And if you think about that, often there's a delay before you even issue proceedings, and then another delay of 9 to 12 months before there's resolution. Sometimes people have separated 3 years earlier, and they still haven't decided what's going to happen to the family home, or how the assets are going to be split, or what maintenance they're going to get. And people really are in a state of turmoil and indecision and limbo. And so it is a very stressful process.
Yeah, I find that period of limbo is actually very damaging when it lasts too long, because there is so much uncertainty. There's a lot of stress, a lot of tension usually. Sometimes the parents are still cohabitating because they can't make a decision. And it's just really harmful for everybody. And sometimes speed has a big advantage in those kind of contexts.
It can be very difficult when they're both living in the same house, and sometimes there's absolutely no choice. And where there's children involved as well, it's a very unpleasant environment, and very, very unhealthy environment. And they need to disentangle themselves sooner rather than later. And I feel very sorry for people in that situation.
Yeah, and it's really, with the economy these days, it's getting harder and harder for people to be able to afford two houses. So until they're able to sell that family house and come to an agreement, everyone's kind of stuck there.
Yeah, exactly.
And in terms of the hearings themselves, so the individual hearings, Jackie, how long do those typically take? We're talking 20 minutes, or are we talking a couple of hours?
Well, I mean, if it's a first hearing dispute resolution appointment or a dispute resolution appointment, they're usually listed for an hour each. The same for first directions appointments in financial remedy matters and financial dispute resolution hearings. Although with the latter, you'll turn up at court with your positions, you'll see the judge will give an indication, and will send the parties out to negotiate. So you might be at court all day negotiating. As to the final hearing, it depends how complex the case is, how many issues there are, how many witnesses there are. But commonly, cases can take 2 to 3 days to resolve if it's a final hearing.
When people come to court, whether it's physically or virtually, can they come accompanied by somebody who's, a trusted friend or somebody for moral support? How does that usually work?
Well, yeah, yes. I mean, I think judges are usually sympathetic to people being accompanied by a friend, and there's a process called Mackenzie friend, which is somebody who can attend court with them who is not financially interested in the outcome of the case in any way, who's there to quietly give advice and assist them and to take notes as a support. So that's always a possibility. Sometimes you find that the other side objects to that if that person really has got an interest in the outcome of the proceedings. So that can in itself be quite contentious. But the reality is you can't just have somebody sitting in to those cases who happens to be a friend or relative unless they are actually there to have a role such as a supportive role as what's called a Mackenzie friend.
Yeah. And so what happens if one of the parties is not happy with the outcome? Once the judge has rendered a decision in the final hearing.
Yeah, well, there is an appeal process. They've got 21 days to appeal. They need to seek permission to appeal first. If the trial judge doesn't give them permission, they need to go to the appeal judge to get permission. But it's not that straightforward, because you can't appeal just because you don't like the outcome. To be successful in an appeal, you've got to show that the judge was plainly wrong in the decision that he or she made, or that there was a procedural irregularity. So the bar is quite high.
Yeah.
Of course,
it's
there
not
is.
just because you're not happy.
No, exactly.
Yeah. So I love to finish my podcast by asking my guests for tips. And in your case, I guess what would be your 3 tips to someone who's preparing to go to family court for a hearing?
Well, I'm going to give one tip, and it's a really big tip. And I think I've said this, and it's a theme that I've given throughout the whole of what I've said so far. Don't go to court. Try everything else to find a non-court dispute resolution rather than going to court. That's the best tip that I can possibly give, I think, to anybody. And there are lots of options out there other than court. And I've mentioned them already. Mediation, there is a real sort of groundswell of support by the courts. Everybody is required to attend what's called a mediation information assessment meeting to find out about non-court dispute resolutions. And courts today, with current changes to the family procedure rules that came into place only a few days ago, the 29th of April, now give the court the power to adjourn cases if they think that parties haven't taken that step of looking to find a non-court dispute resolution process. So, it's front-loaded to look elsewhere, if you like.
I think that's a very important tip, and really one that I also try to reiterate time and again with my clients. And I think that there is an education piece around people understanding what those non-court dispute resolution options are. Yes. And we're heading in that direction. And I can see that there's more and more information out there. And that's really going to be the key for people to realize that a divorce isn't necessarily a war and doesn't necessarily have to unfold in a court of law.
Absolutely. I completely agree with that.
Well, thank you so much, Jackie. It's been wonderful chatting to you. And thank you for sharing all these insights from the inside.
It's been my pleasure. Thank you, Clary.